Right, so it takes a special kind of government to boast of being all about law and order while abandoning its own citizens to a foreign military, and then prosecuting them when they come home. That's precisely what Keir Starmer's rancid Labour administration has managed. When Israeli forces seized the Global Sumud Flotilla, including several British participants in international waters, ministers fell mysteriously silent, as if the Vienna Convention were a quaint suggestion rather than a binding treaty they were signed up to. No protests, no statements, no fuss. Days later, one of those same campaigners, Sarah Wilkinson, was back on British soil, only to find herself arrested at Heathrow and now facing terror charges. In the Starmer era, apparently defending British citizens is optional, but defending Israel from embarrassment is very much policy. It's law and order for the cameras and lawlessness wherever it might cause diplomatic inconvenience. Well, he might not get away with that for much longer, as the law might be reaching out for him. Varying degrees of abuse in detention. That is the verified sequence of events as we know it now. But what happened next, what did not happen, is the heart of this story. The UK Foreign Office acknowledged awareness of the detentions. It apparently offered consular assistance. It did not demand release of its own citizens, though. It did not issue a formal protest or raise the matter in Parliament. There was no press conference, no ministerial statement. There was nothing. This silence was not an oversight, it was a deliberate decision on the part of the government. And we know this because a spokesperson acting on behalf of the government said the detention of British citizens from the flotilla was a matter for Israel. Now, the Vienna Convention on Consular Relations, which was ratified by this country back in 1963, defines a clear duty in such circumstances. Article 5b states that consular officers must protect in the receiving state the interests of the sending state and of its nationals. Article 36 requires prompt communication with detained citizens. A Commons Library briefing issued just last year explains how these duties are to be interpreted. The UK may make representations, but cannot compel another state. In practice, that discretion allows ministers to remain silent whenever the detaining power is an ally, and they can choose that alliance over the people that have been detained, even when that's British citizens. Human rights lawyers have long argued that this discretion should be replaced by obligation, though. In 2024, the charity Redress published Protecting British Nationals Abroad, setting out 15 principles for a statutory right to protection. And one of those principles reads, where there is credible evidence of serious human rights violations, the state must act. The detention of British civilians by a foreign military in international water meets that test precisely. International maritime law actually reinforces it. Articles 87 and 90 of the United Nations Convention on the Law of the Sea guarantee freedom of navigation on the high seas. Boarding and seizing a foreign vessel without consent violates that freedom. It's piracy. When such an act targets British citizens, as this very much did, the UK government is entitled, and I would argue obliged, to protest that. But by doing nothing, Britain effectively accepted that Israel could exercise jurisdiction over its nationals beyond its own borders. That's not diplomacy, that's abdication. Sovereignty means the state protects its people from the arbitrary powers of others. When that protection depends on who the other is, sovereignty becomes a matter of politics and not law. It's just a word used for semantics. The passengers of the Global Sumud Flotilla were civilian volunteers, including British nationals taking part in a humanitarian mission to Gaza. The international coalition behind the voyage has said its crews included medical workers, clergy, aid volunteers, a pattern consistent with this mission and those that came before it, going back 15 years now. None of them carried weapons, all carried the assumption that their government would defend them if detained. That's surely not a high expectation of people. Yet in the case of the UK, it did not. According to reports, relatives of the detained Britons sought information through the Foreign, Commonwealth and Development Office, but received only a confirmation that consular assistance had been offered. There was no ministerial statement or detailed account of government contact that has been published. The FCDO has not released correspondence or briefings about the detainees, and no public record indicates that it protested the detentions. The human reality is what gives this case moral weight. These were citizens acting within their rights under international law. Their detention was not an act of war, it was an act of suppression. The silence that followed from the government was a policy choice dressed up as procedure. So in light of all of this, therefore, the Public Interest Law Centre, or the PILC, has issued a pre-action protocol letter to the FCDO and number 10 Downing Street, formally threatening them with a judicial review now. Starmer faces a day in court over this. The letter accused the government of failing its duty of diplomatic protection. It invoked the Vienna Convention and the European Convention on Human Rights, specifically Articles 3 and 5, which protect against inhuman treatment and arbitrary detention, of which much testimony from detained flotilla volunteers has been made. The PILC has given the government 14 days to respond. If no satisfactory answer arrives, it will apply to the High Court for permission to proceed. The case, if filed, would mark the first time a British government has faced judicial review for refusing to defend its own citizens against an allied power. The optics of such a case would be eye-wateringly catastrophic for Starmer's regime, and deservedly so. So I wonder if they're going to pony up an excuse. That is the line connecting silence to consequence here, though. The government that abandoned its citizens may now have to answer to them in court. If the High Court agrees with the PILC, it could issue a declaration of unlawfulness and order the FCDO to codify a clear, non-discriminatory policy on protecting nationals abroad, and the result would be historic. It would turn a moral expectation into a legal duty, finally. And frankly, it seems bizarre to me that there is no law compelling the government to protect UK citizens abroad already. But Starmer has managed to make this dire situation even worse for himself. You see, while his government avoided confronting Israel, it used law aggressively at home against those who were the subject of this PILC challenge. In August of last year, following the arrest of independent journalist Richard Medhurst, another journalist, Sarah Wilkinson, was raided by anti-terrorism police. She was later released on bail, an act to try and coerce her into silence. Well, she refused to be silenced, and she happened to join this latest flotilla mission as one of the Britons involved. Then upon her return, she, like Medhurst before, got arrested upon touching down at Heathrow. According to West Mercia Police, Wilkinson now faces 5 terrorism-related charges: encouragement, dissemination, 2 counts of supporting Hamas, and 1 count of failing to comply with the Section 49 Reaper notice. In other words, refusing to give the police a password to access her devices. Wilkinson is a long-time Palestine solidarity campaigner. She was detained shortly after returning from the Middle East, where she had taken part in this humanitarian mission. The authorities have not connected her charges to the flotilla itself, but her immediate arrest upon return has raised obvious questions about that. The British government did not object when Israel... In August of last year, following the arrest of independent journalist Richard Medhurst, another journalist, Sarah Wilkinson, was raided by anti-terrorism police. She was later released on bail, an act to try and coerce her into silence. Well, she refused to be silenced, and she happened to join this latest flotilla mission as one of the Britons involved. Then upon her return, she, like Medhurst before, got arrested upon touching down at Heathrow. According to West Mercia Police, Wilkinson now faces 5 terrorism-related charges: encouragement, dissemination, 2 counts of supporting Hamas, and 1 count of failing to comply with the Section 49 Reaper notice. In other words, refusing to give the police a password to access her devices. Wilkinson is a long-time Palestine solidarity campaigner. She was detained shortly after returning from the Middle East, where she had taken part in this humanitarian mission. The authorities have not connected her charges to the flotilla itself, but her immediate arrest upon return has raised obvious questions about that. The British government did not object when Israel detained British citizens. It has now charged one of those citizens, or a closely linked activist, with terrorism offences. It's twisted. A government that failed to protect foreign detention of its own people now prosecutes one of those people for protesting a genocide. As if the government didn't sicken us all enough before. Keir Starmer presents himself as a champion of law and order, the former human rights lawyer who has seemingly thrown everything he built his career on, everything he supposedly believed in, clean out of the window for political advantage and gain. This pattern of selective enforcement exposes law for the powerless, discretion for the powerful. Under his government, police have used the Public Order Act to limit marches, arrest pensioners for holding placards, and monitor students for pro-Palestine speech. At the same time, Downing Street refused even to condemn a foreign military seizure of British civilians. The Commons Library briefing warns that consular assistance should be applied consistently and without discrimination. Redress adds that selective protection undermines trust in the rule of law. Those statements are not ideological, they're constitutional. The law that is silent before power ceases to be law, it becomes admin. And this is why the PILC challenge matters so much now. It's not just about flotilla passengers. It's about the meaning of citizenship itself. If the state can pick and choose when to defend you, the bond between citizen and government has become conditional. Law turns from protection into permission. This is not Britain's first moral retreat either. In 2002, the Court of Appeal in Abbasi versus the Secretary of State held that the government had a moral and political duty to assist a British detainee at Guantanamo Bay, but declined to enforce it. The courts recognised the duty's existence, but not its justiciability. Since then, cases such as Belhaj versus Straw in 2017 have expanded the judiciary's willingness to review foreign policy complicity in abuses. The PILC's threatened action follows that same trajectory, asking the courts to convert moral duty into enforceable law. Historically, the UK intervenes forcefully when its citizens are detained by adversaries, but hesitates when the detaining power is an ally. And here we have another example of that. Another example would be the contrast between the high-profile campaign for Nazanin Zaghari Ratcliffe, for example, and the silence over the Sumud Flotilla. It's all just a matter of public record now, the hypocrisy of that. Just compare those two situations. The principle appears to be the friendlier the abuser, the quieter the protest from the government is. That inconsistency erodes credibility abroad and our rights here at home. It tells the world that British protection is not universal, it's geopolitical. Mainstream coverage of the flotilla was fleeting as it was. Independent media picked up the slack as usual. This absence is part of the story too. When British citizens are detained by adversaries, the tabloids fill the pages. When the detaining power is Israel, the story disappears into the margins. The silence of media mirrors the silence of government. They're all in it together, allowing both to pretend that nothing has happened. And that lack of scrutiny has consequences. It deprives citizens of knowledge, it prevents accountability, and it normalises a hierarchy of outrage. Full sympathy for those detained by enemies, none for those being mistreated by allies. If the PILC proceeds and wins, it will set a constitutional precedent that the duty of protection is legally enforceable. Ministers will no longer be able to hide behind consular discretion. The FCDO will have to publish clear criteria for intervention and apply them without political bias. If the court rules against PILC, the political fallout may still be severe, though. The case itself exposes the contradiction, doesn't it? That the government had to be threatened with legal action to defend its own citizens. For a Prime Minister who built his career on legality, that is reputational poison, not that he's got a great deal of reputation left. Either outcome still forces a reckoning. The state must choose between upholding its professed rule of law values or admitting that those values stop at Israel's border, or even international waters miles outside of those borders, as this case might be. The implication extends far beyond one flotilla or one activist. If this silence stands, every British aid worker or journalist operating in conflict zones suddenly becomes vulnerable to the state no longer having their back. The passport ceases to be protection, it becomes a political token. Domestically, the broad use of terrorism statutes against solidarity movements narrows the space for civil society. Today, the target is Palestine Action. Tomorrow, it could be climate protesters or other anti-arms campaigners or journalists exposing war crimes by those same allies the UK government put before its own citizens. This is how democratic norms erode, not with a single scandal, but through the slow normalisation of selective enforcement. The redress report warns that failure to protect nationals abroad erodes the integrity of the state. That erosion is very visible right now. The Starmer government's blend of foreign deference and domestic aggression is not an aberration, it's the system functioning as designed. Sovereignty once meant that Britain would defend its citizens wherever they were. Now it appears to mean the right of ministers to decide when those citizens are politically convenient. Citizenship once implied a reciprocal duty, now it guarantees little more than the right to pay taxes and obey laws. And this transformation has moral consequences. A state that abandons its own people cannot credibly lecture others on human rights. It cannot invoke international law to condemn adversaries while ignoring its allies' violations. It forfeits the moral authority that underpinned British diplomacy for decades. So the PILC case, the flotilla incident, the prosecution of Sarah Wilkinson, they're all symptoms of the same condition. The replacement of principle with alignment. The rule of law has been redefined to mean loyalty to power. For the families of the detained Britons, the legal debate's just semantics. What they remember are the unanswered calls, the sleepless nights waiting for news, the realisation that their own government would not speak for them. Sarah Wilkinson faces a different ordeal, months of legal limbo and the prospect of prison. Her supporters call it persecution, the police call it enforcement. Whatever the court decides, the effect is the same. A citizen who tried to expose a humanitarian crisis gets treated as a criminal, while those who enabled that crisis are treated as partners. The remedy is not rhetorical outrage, but legal reform, and fast. Britain needs a codified duty of diplomatic protection, clear, enforceable, and immune from political discretion. The redress model provides a fantastic blueprint for that, so I do suggest you have a good read of it all. Parliament could adopt it with a simple statute requiring ministers to act when citizens face credible risk of rights violations abroad. Such a law would not weaken diplomacy at all. It would just restore some legitimacy. Domestically, the government must narrow its definition of terrorism to exclude non-violent political protest as well, rather than allow the vagaries of the Terrorism Act of 2000 to have widened to a chasm to include such things. The criminalisation of solidarity is unsustainable in a democracy that claims to value free expression. All the facts are now on record. British citizens were detained by Israel in international waters, a criminal offence. The Starmer government did not object to it. The Public Interest Law Centre has threatened to take that silence to court. A British activist faces terrorism charges for her Palestine work. The same government that refused to protect her abroad will now prosecute her at home. These events are verified. Together they describe a state that applies law as hierarchy, rigid below, pliant above. It's not simply a foreign policy failure, it's a constitutional one. A government that enforces law against the weak and waives it for the strong destroys the equality on which law depends. Whether or not the courts intervene, history will still record that citizens had to threaten their own government with its own statutes to obtain the protection their passports apparently promised. That's the measure of the moment. The rule of law, once Britain's proudest principle, now functions as political decoration. Until it's restored as an equal standard, binding ministers as well as protesters, the phrase law and order means nothing more than power deciding who the law is for. And for as much as Sarah Wilkinson might be facing legal accusations of complicity with a proscribed organisation, complicity in genocide is a far worse accusation. And with Italy's Giorgia Meloni now being the first European leader to face a formal investigation for complicity in Israel's genocide, a lot of other European leaders, not least our own government here once again, might be right to feel a little bit nervous about that. Check out this video recommendation here as your suggested next watch to find out a little bit more about that. Please do also hit like, share and subscribe if you haven't done so already, so as to ensure you don't miss out on all new daily content, as well as spreading the word and helping to support the channel at the same time, which is very much appreciated, holding power to account for ordinary working class people. I'll hopefully catch you on the next vid. Cheers, folks.